Hi, and welcome to this edition of Happy Space Hot Topics. Return to office, the legal side. So today we're digging into what's going on in North America in particular, in the legal sphere, around this conversation of mandates to return to the office. There's a lot of tension. Certainly in Canada, there's been some headlines recently, and we know in the US there have been organizations as well, plenty, who have been telling their workers to get right back to the office. And I've been curious to have an informed discussion from a legal perspective for employers and employees who are in this conversation. We end up talking here about undue hardship, and clearly organizations have to accommodate up to the level of undue hardship, and there's a fair burden of proving what that is. But I was make a point towards the end of our discussion that this is really about undue hardship on both sides. There shouldn't be undue hardship for someone who has a disability, caregiving responsibilities, reasons why it's difficult to be in the office to perform at their best, against undue hardship for an organization. And what's behind that? Is it cost prohibitive? Is it mindset? Is it control? Is it complexity in managing a dispersed team? What's behind all of the hardships that's there, and how can we work together to meet each other and design and co-create a better way of working? In this discussion, I am very honored to have Laura Williams of Williams HR Law in Toronto, Madelena Viksne of Levitt, Sheikh, which is a premier employment law firm in Canada, and also Stuart Silverman, bringing in the US perspective from SMS Law. I invite you to hear their wisdom, and if you have questions, reach out to us on LinkedIn. And you can find us all there, and let us know what you thought. Pop a comment below in the comments as well. We'd love to hear from you, and keep the conversation going. There's a lot of opportunity here, and as you'll hear in the episode, Stuart ends on a very positive note. So please enjoy. I wanted to start with probably the biggest question, which is, if you're facing the thought of being let go because your company's moving back to a return to the office mandate, is this something an organization can do? Is this something you need to be afraid of? What are you actually at risk of in these return to office mandates if you've been used to working from home, were hired in a condition where you work from home? What's going on? And Laura, I'm going to start with you, and then I'll move to Stuart and then to Madelena.
Certainly. So yes, Claire, this is the hottest of hot topics in the employment law bar, but just generally for organizations right now. And I think we have to kind of just stop and remember what got us here. So naturally, we were all thrust into an event that was not planned for, and that was just unpredictable in terms of the way that things were playing out within many organizations. And a lot of leaders were caught flat-footed. Right. And we had a lot of organizations that weren't equipped and weren't ready to now convert how they work and how they provide service to a remote reality. And so there was, understandably a lot of misstepping with respect to setting expectations with respect to what the way forward would be. So what you find with a lot of organizations now is that you may have had some leaders providing some assurances with respect to how things would play out on the other side of the pandemic, and are trying to recourse because maybe they miscalculated, they've kind of miscalculated with respect to the best way to provide service to their customers, et cetera. Maybe they've underthought how important collaboration is to innovation, to providing service, to culture. And so now what we're finding is there's a lot of recoursing with respect to, okay, we did think that perhaps we could sustain, working remotely beyond the official end of the pandemic, but now we're rethinking it because we didn't really think through all of the implications to how we work internally in terms of how we communicate as well as how we provide service. So one of the things just to put on radar with respect to the implications for organizations is that, if you have provided any type of assurances or made overtures, particularly to employees that you hired during the pandemic who were working remotely and may consider that to be a condition of employment going forward, that if you are going to change course now, that there could be exposures to constructive dismissal allegations, with employees claiming that now you're unilaterally changing what is considered to be some of the material and fundamental terms and conditions of employment with respect to how the work will be performed and being remotely. So it really is tricky terrain. And I'll stop there to give some space for my panelists to chime in. But certainly, foundationally, I think what's happened for a lot of leaders is we were in a context where we're dealing with things that haven't seen before and not fully thinking through how you have to be intentional with respect to making sure that employees understand, new and existing, understand what would be the kind of new normal within the organization going forward. And just also, and we probably can get to this because this is a big issue, is making sure that if you are going to change course, or if you're going to require a certain kind of work from home or remote working arrangement, that you really underscore it with a solid why as to why we are going to work in this manner. It has to make sense, because if it doesn't make sense, not only do you perhaps face legal risks, but you also are going to have retention issues.
Mm-hmm. Yeah.
Oh.
Lots in there. I want to definitely come back to the point about collaboration, but I'll leave that thought on it. And Stuart, I want to hear from you in respect to what Laura said and your own thoughts. What do you think here is going on if someone's going to be ordered back to work?
So I think Laura has really, quite frankly, nailed it, meaning it's really what we're seeing as the return to work is part of a bigger issue where, you've had companies that were just flying along and things of that nature, and now they had issues that came up and there was lack of planning. We're doing the best we could and things of that nature. It's part of a bigger issue, which means we'll see it manifest its way, somehow, in some other thing coming down the pike between management and employees. How it plays out here in the U.S. is slightly different, because in the U.S., pretty much is employment at will, so a person can be hired for any reason, good, bad, indifferent, so long as it does not violate a state or federal law. That's the general working premise here. So even if a person was hired, let's say during COVID, and it was a work from home, when the company's work from home, the company can say, yeah, we need everybody to be back, and you're stuck with that policy. There are plenty of exceptions, and it's the exceptions are the fun parts here. The big exception here is going to be if a company qualifies either federally under the ADA, the Americans with Disabilities Act, or there are plenty of states that have state law equivalents that'll do that as well. And the amazing thing here is the silver lining to this whole thing, if there could be a silver lining. There are things that are disabilities today that weren't disabilities 5 years ago. There are reasonable accommodations today that weren't there 5 years ago. And it doesn't just help the person, in the pandemic, and it helps other people, let's say with mental health issues, things that didn't show themselves physically and stuff. There's a lot of stuff that's going to get eventually unpacked out of this whole thing down the road.
Yes, I'm so all over that. Before I come to you, Madelena, I'll just share a little bit about why this topic is so passionate for me. When I was in the corporate world in 2007, I found the construct of work to be so exhausting that for my job, which was 90% done over the phone, I had effectively been working 50% from home. And prior to that, I'd worked fully from home in a job and proven that I could do that successfully. but I was up against a leader who really, her preference was, I want your butts in the seats, essentially. Whether she was traveling around the country or not and able to meet with me didn't matter. She wanted me there. And no amount of lobbying, no amount of conversations with senior levels, nothing made the argument to advocate for that flexibility. And I love that you've said in the last 5 years, there are so much more awareness of disability and beyond. I think, as somebody who's neurodivergent with this trait of high sensitivity, Toronto's transit system is not for the highly sensitive. I can tell you that right out of the gate. It's horrible. So I think that there's a whole line of inquiry I'd like to get to right after I come to you, Madelena, on this whole concept of how are accommodations being given? What can people who are listening to this, who say, well, what do I use as an argument that actually is going to have some weight here? So thank you for bringing up that point. Madelena, I'd love to come to you and see what would you like to add to the conversation so far about what someone would do in this position?
Yeah, so I mean, I echo the points of my colleagues here. Obviously, what was being done at the time was required at the time, and also everybody was basically flying by the seat of their pants. The instructions or directions that we were getting from the government, I mean, even in employment law, the law was changing like on a near daily basis in terms of what legislation applied to employees, employers, how we were going to advise our clients. It was quite complicated actually to stay on top of like what was the current, like, for example, idle legislation, and what we were predicting maybe would happen later was often not what actually did happen. I think if you started during the pandemic, there's potentially a difference between somebody who worked just fine from the office prior to the pandemic, because there's also obviously a difference, because, sorry, you started your employment with that being a term of your employment, and over 18 months or whatever time you worked from home, whether it's in your contract or not, it could likely have become an understood or condoned term. I think if you started prior to the pandemic and you were doing your job just fine before that, then you have a bit more of an uphill battle, I suppose. And it obviously, assurances, as my other colleague said previously, would also come into play. But there is also, I just need to say, a difference between preference and convenience versus a duty to accommodate, or what would trigger a duty to accommodate. Employers, like, just because it's easier for you, because it's, it makes things more convenient for you, doesn't necessarily trigger the duty to accommodate for an employee. For an employer of an employee. There has to be something more than that, and that something more than that can be something like family status, which is also protected under the Human Rights Code, or marital status, or there's several different things in addition to disability which could be employed. So, for example, if you and your husband both work in different cities than where you live, and your kid's daycare closes at 4, and there's often snowstorms in the area, both of you can't really realistically get there by 4 to pick up your kids in the event that happens. And somebody has to be there if the kid gets sick, and it can't be an hour and a half away. That is, in my opinion, a valid basis for family status accommodation, allowing you to work from home, especially if you were doing your job just fine remotely previously to that, and there is actually no impact on your work product. And your ability to engage with your employees. I mean, in those types of situations, and in any situation with accommodation, there's both a procedural and substantive obligation of the employer and the employee. So the employer and employee have to sort of explore what the options are and then implement the accommodation. And that exploring period of time, the procedural accommodation, really does need to include like conferencing with the employee and understanding and seeking more information about their restrictions, and sort of canvassing what it is that you might be able to put in place or how you could accommodate them. Just as a reminder, employers are not entitled to any diagnostic information at any time, but they are entitled to understand what your restrictions might be. And they are entitled to seek, medical support for requests for accommodations if it has to do with a disability. And for example, for family status, you may have to demonstrate that you've explored every other option available to you, in respect to like calling other daycares that might have later end dates or end times or whatever. But it's not a stringent threshold. It just needs to, you will need to have some kind of support in order to back yourself on any accommodation request for the most part.
Yeah. Thank you for that understanding. There are different arguments to perhaps be made about it. I want to come back to Laura and maybe see if we can expand on this a little bit, because I'm in my own particular situation, and for many people who are neurodivergent, diagnosis is privilege. I'm getting a t-shirt with that made on it too, to go with my advocacy t-shirt series here. Diagnosis is very much privilege. It can cost thousands of dollars in our health systems. It may be up to 2 or more years to actually get a diagnosis. So what happens then practically when you have not just convenience, it's actually there's disability there, not yet diagnosed? How do we talk about this, and how do we get this medical support that Madelena was talking about to be able to build an argument? Are we grasping here, or is there something we can lean to in terms of case law, or what would you recommend here? What do you think the chances are?
Well, again, if you're seeking an accommodation based on a medical issue, then part of the kind of the procedural accommodation process that Madelena referred to does involve getting the medical, and again, not diagnosis information, but prognosis information. And prognosis information is important to understand, because what that's highlighting is what you're able to do and what you're not able to do. So what the limitations are as it relates to your role that you're performing. So that's really critical to what an employer has to understand. That's why there has to be that process of, speaking with the employee and understanding what it is that requires accommodation.
Can I just ask
Sure.
you there, where does the commute fit into this? Because it's not part of the job per se,
Right.
but it is part of being able to get to the job. So where does that fit?
Well, in large measure, the commute hasn't been part of the picture. What you're finding, though, we are evolving, as Stuart mentioned, south of us, and also in our context with respect to how accommodation and the need for accommodation is being considered. Right, there's a lot more, because we've had such a focus on the destigmatization of mental health issues and an understanding of just how pervasive mental health issues are. The mental health crisis that we find ourselves in, it has been dubbed the eco pandemic, right? And so with that, you're finding a lot of employers going a little bit off of the kind of stringent, what are the legal requirements, and more embracing the practical. The other piece is, I speak as a lawyer and as an employer, is naturally, particularly when you have a solid team, but irrespective of the status of your team, we've just come through a period where the labor market has been challenging. And so retention is something I mentioned earlier, but I mention again, because that's a big piece of it. Culture, and making sure your culture is stabilized, because we've come through a time where we've had to recalibrate our culture because we are working differently. And so a lot of employers will consider, a little bit more liberally and broadly what they and how they will accommodate. The only thing you have to be careful about is, what you do. For one, although accommodation should be done on a case-by-case basis, you are going to have others that are going to have their expectations set by virtue of how an employer approaches accommodation. So, there's it's very complex, but it is multifaceted now, because yes, there's the legal piece, but there's also, right now, in a time where employers are really grappling at stabilizing or organizational culture, that they're taking a lot more into consideration.
Thanks for those insights, Stuart. When you think about this from a U.S. perspective, what are you noticing and maybe you can even expand on how you're seeing these new disabilities and challenges being actually respected in the workplace?
Right, you're seeing it again. I'll give you a couple examples. Their asthma is something that you would not traditionally consider a disability. And in fact, when the ADA was first passed, asthma was not a disability. But about 15 years ago, the ADA was amended, and it doesn't look at what the condition is, but it's how it affects the person. And
Yeah, I've
asthma,
had two sisters hospitalized for asthma, so I'm like, it's a thing. It's definitely.
was 9 times in the last year for asthma, so it's near and dear to my heart. So, but it affects the ability to breathe, and it would easily today fit under the ADA. I use asthma as an example because so many people post-COVID with all sorts of similar type conditions were in the rush to say, I need a reasonable accommodation. And you know what? And for the most part, their employers are giving it to them. And do they have to? Hard to say, but probably yes. But there's a process that needs to be go through, and employers, what they're finding out the hard way here in the U.S. is if you don't go through the process, you're going to get sued like, a lot, and you're going to lose them, let's say 11 times out of 10. It's that critical in the U.S. going through the process. So not going through the process will get them in trouble. And so employers are generally told, listen, if a person makes a request, be reasonable and flexible. Just try to do that because, that's what you should try to do. So a lot of these things are going, and so people can understand post-COVID, anybody with any sort of breathing issue, with any sort of infection issue of that nature, and depending on what type of job they do they really, 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 really need to be in the office versus what the job description says they need, and stuff, that's going to suit them well. So that's what's going on. There's some sort of flexibility going on. There's some sort of looking at these issues a little bit differently, but that's generally the type of things going on. But Claire, I want to come back just to one point, that another difference between the US and Canada, which you'll appreciate, which maybe can help out in the future. Here, commuting is part of the job. So if a person were to make a request like, I can't get to the job on time because of whatever the situation is that's slowing down their commutes from a physical perspective, they're going to be entitled to, that's going to count for an accommodation here.
That's fascinating. What a
Yeah.
difference. I mean,
You're not paid during your commuting time, are you?
Not paying during commuting time, no. But let's say they got to get to work late. They're going to get their half hour late because of
Family status would apply to that kind of situation as well. Sorry to interrupt you.
Yeah, and that's okay. Whatever the
I think I cut
situation.
you out.
Yeah,
and this is good for you guys too.
it is. If I can just jump in as well, just to be clear, I'm not saying that in no case would commuting be part of it. If let's say, for example, you had a limitation that, let's say, for example, you have a mobility limitation, right? Then naturally, that may impact your ability to do a job, but it could also profoundly impact your ability to get to your job. So, that it does come into play, but not necessarily. I know in the context of what you were asking Claire earlier, not necessarily for all requests for accommodation.
Actually, all other options need to have been explored prior to, like, up to the point of undue hardship is quite a high threshold, which is the threshold in Canada for accommodation. But that also requires on the employee side to have explored all other options available to them in order for the employer to have to implement some extra new additional step that or like aspect that maybe wasn't available to the employee previously. Such as, I mean, I don't know that, I've never heard of this happening, but like paying for the employees Uber in order for them to get to work because the financial strain is too much and they can't take, like, I have never seen that happen. But it would be
thinking of things like immune compromisation, where being on the subway is just not a safe place to be because of crowds. That there are a number of different things that make shared public transit not a comfortable or safe option.
Right, but you'd have to demonstrate,
right?
You'd have to demonstrate that you've explored other options such as carpooling or being able to like pay for Ubers or taking a, some other aspect, some other way to get there, in order to have sort of an extraordinary level of accommodation for your particular case. I guess I'm not saying that it's not required. Undue hardship is a very high threshold, as I said before. The employer really does have to take significant steps. And in the circumstances that we're discussing right now with respect to commutes, very likely work from home, if you were able to do it before, makes way more sense than adding in some sort of transportation aspect to the employment relationship. But I did also just want to say that, like, in Canada, at least in Ontario, there's the commuting is not the courts are not overly, I suppose, sympathetic with respect to commuting stuff. For example, there's a duty to look for another job that's comparable if you are terminated as part of your mitigation efforts, and to accept any position that is comparable and reasonably like applicable to you. And there's several decisions that say that that can mean that that job is more than 100 kilometers away from where you live, and that's okay, and that's still considered to be a reasonable. Like you would have to explain why you can't take that job. It's not every single decision, but there are several decisions where the numbers, in my personal opinion, don't make sense. I'm not going to drive up to Bowmanville from Toronto every single day to work my job. And I wouldn't apply for a job there, notwithstanding what opportunities might be there. But
like, well, I think one of the companies in the US said their radius was 50 miles. I think if you were 50 miles or more, you had to be in 2 days or 3 days a week. And if you weren't, then you didn't have to be. And so, Lisa, I see your hand. I'm coming to you. But I am curious on what grounds people make these decisions about what's reasonable to add into somebody's life.
There's just a couple cases that are very unfavorable to the employee who is looking for looking for a new job, where they've said, I didn't apply to this job because it was 150 kilometers away. And the court has said, well, it's actually basically the same job you already had. And that's not too far for you to drive.
And so this is a judge. I don't know. Just understanding the system. This is a particular judge deciding that
several decisions, but different judges.
Decisions? Yeah. So,
and I mean, it doesn't apply across the board either. Like, just to be clear, it's not every single decision hasn't said this makes sense to us, but it isn't. It isn't something that I haven't had come back at me as the plaintiff's counsel. I don't think it makes very much sense, frankly, myself, but it doesn't, the decisions do exist out there that say that is a reasonable, that should at least have been applied to, in the context of mitigation. I did have just one more point. I wasn't saying necessarily that, just to circle back to Laura, that diagnosis, and in your, circumstances that you were describing earlier, diagnosis isn't necessarily required in order for you to receive medical support from your doctor. There's also often with something, that isn't necessarily diagnosed, there could also be corresponding or correlated things like anxiety or so on that maybe are more diagnostically accessible, that your GP can do without you having several extra assessments that maybe cost out of pocket. And so those types of things would be things that I would advise if you're looking for a accommodation and on a medical issue that maybe isn't specifically diagnosed for you at this time, or isn't diagnosable technically. You can get a note from a therapist that supports that you can't, manage crowds or whatever. And then you can also get a note from your GP about the anxiety, and it could be acute anxiety or something. I'm not a doctor. I'm just saying words. But anxiety, these types of things, like you describe to your doctor the symptoms that you're experiencing when you're in the situation that is causing you, to feel overwhelmed. And they don't, because you're not even sharing the diagnosis, it doesn't necessarily require a diagnosis. It can just be, this isn't something that is doable for my patient. It's causing them to experience, unpleasant symptoms or whatever. And as a result, or due to their medical condition, all a doctor's note really needs to say is, due to their medical condition, my client requires XYZ. Or my patient requires and she'll be under my care and reevaluated on an ongoing basis.
And just to I was more doubling down on your point, Madeline.
No, I know. I was
Making a distinction, but you're quite right. When it comes to requests for accommodation that relate to certain types of conditions, like mental health conditions, sometimes it's hard to not reveal the nature of what the condition is through the limitations, right? So,
visible
and some,
disabilities.
indeed, right? And so, no, I was more just doubling down on you saying not diagnosis, but it does become sometimes difficult to parse and not reveal depending on what's being requested.
Particularly where it's creating a specific restriction that the employer is entitled to understand absolutely what the restrictions are, because it's impossible for them to understand how they could possibly accommodate you and for them to engage in the accommodation process appropriately if they have not been provided with the details of the restrictions. Now, this could be, you can't work in a busy, loud environment. You don't do well in crowds. Those can be the way that the restrictions are described by your doctor. But your employer does need to understand what it is that is the problem in order for them to help you find a solution. And I just would really echo sort of Stuart's point as well, that I think that it's really important and essential, especially in I think always, but particularly where there's issues with retention and so on, for employers to really consider um, the the benefit of working cooperatively with your employee. It doesn't have to be an all-in solution in order for the accommodation to be appropriate. If you are only going to be asked to come in once a week for a specific thing that you have to be in person for, that's something that you could attempt as the employee and should probably attempt as the employee. It's not overly burdensome, and at minimum, in order for you to be the employee participating in the accommodation process, if you've come to some sort of compromising arrangement, it shouldn't ever just be like hard no on either side. There certainly needs to be like the parties working together in order to come to some middle ground or some workable solution that accomplishes the goals of both sides, with obviously the view to the fact that accommodation is a right. There is also an obligation on both sides for there to be communication and cooperation in the process.
Thank you. I just want to say that I think there's been a massive shift in understanding accommodation as a right since 2007 when I raised the question. I think the pandemic seems to have bubbled this up as a topic, and the commute is now part of the conversation. I want to come to Lisa, who had her hand raised some moments ago, but I haven't forgotten you had a question. We're about just over halfway through, and it's a good time to bring you in, Lisa. What would you like to ask?
Thanks so much, Claire. It's a fascinating conversation. And I just 2 points, picking up on what Stuart said regarding accommodation for non-apparent disabilities. And from what I believe I understand, it's a tremendous portion of people in the workplace do not disclose their non-apparent disability. I believe it's 80% or more, and I don't have that fact in front of me. Given that, I hope that this message, I'm so delighted, Claire, you're shining a light on this, because more people need to be aware of their rights, and more employers need to create a psychologically safe place where people are willing to share their disabilities without fear of stigma or retribution. So I think there's so much work that needs to be done on both sides, but given the lack of certain employers on seeing the importance of accommodation, I hope that employees pick up the opportunity to use their voice to advocate for what they need.
Yeah. Thank you, Lisa. Clearly this is near and dear to my heart. It's interesting just to pick up on what you had said, Madelena, about, trying to be part of the process. In my personal experience, I think I mean, before I took the job, I had said, I need to work in a bright office. I had sort of articulated some of what I needed. And I was put in an office the first day, which was well away, probably 30 feet at least away from windows and with a cubicle around me. And I saw open desks by the window. So I started off this job by saying, I'm going to be sitting over there until that office is needed by somebody else. So I knew the writing was on the wall from day one. It was just not a great fit. But I did offer, like I said, the job is 90% on the phone, and I offered to come in 50% of the time and for any meeting that you need me. Like
Right.
I was putting forward, I'm gonna dance with you. I'm gonna be a good dance partner, but please give me what I need.
It
And that
sounds
was
like your
a hard
employer
one.
failed to accommodate you and to participate in the procedural aspect of your accommodation. I mean, I can't speak to the specifics of what was disclosed to them or anything like that, of course, but I
Mhm.
mean, it sounds like you were working as I recommended, I suppose,
Yeah,
to
exactly.
cooperate
Yeah,
and participate and
yeah.
compromise in the process. And I mean, ultimately, I think most employers, you know, if you're a good employee, most employers will want to work with you and do their best they can. Some of them, I think there also needs to be a bit of sort of understanding on both sides that, like, you know, a mom and pop shop may not understand their obligation to the same extent that somebody like I wouldn't hold them to the same standard necessarily in respect to I hold them to the same standard legally, but I think in terms of like I think there's a lot of anger that comes up in these processes with on the employee side in particular, and a lot of frustration on both sides. And I think that employers and employees should both be educating themselves about their rights and obligations under the Human Rights Code and Employment Standards Act, and you know, non-reprisal and all of that. I think that something I come across often, and I'm sure Laura and Stuart do as well, is like employers maybe think that they're doing what they're supposed to do, but they're outdated knowledge, or they haven't really looked into it properly, or they haven't sought legal advice. And they're not, I would say most of the time, there isn't necessarily malicious intent. I'm not saying always that that's the case. There certainly are bad employers out there, and there's bad, you know, there's difficult employees who are being offered what it is that they're asking for in different in maybe a different or workable way, and just hardlining no, and that doesn't make it easy for the employer to work with them. But I do think that most of the time people are trying to figure it out along the way, and so seeking legal advice on either side is always a good idea to understand what your what your rights and obligations are, whether you're in the employee or employer position. And just, you know, employers need to understand what undue hardship means. It's pretty hard to hit that standard, which doesn't require accommodation. So what that accommodation looks like is then the next step.
Yeah. Thank you. I want to come to Stuart. Actually, go ahead. Go with what you're saying, and then I'll give you a question.
Sure. I want to follow up on that excellent point. I'll give you two examples of the point I'm going to make. One's from the employer perspective, one's from the employer perspective. That's really the same point. The more knowledge that the employee can come with, the better it's going to be. Meaning, Madeline is absolutely correct that the employers think they know what they're doing, but sometimes have no earthly clue of what. I'll give you the more ridiculous example first. I kid you not, I couldn't make this up if I tried. So somewhere shortly after the pandemic was ending, I got a call from somebody who wanted me to help them out to get a reasonable accommodation from their employer. The person's job was a researcher. During the pandemic, the person went to the office, sat in a closed office, sat 50 feet away from people, and did research on the computer. It was before the pandemic. During the pandemic, the person did the same job at home. They wanted the person to return to the office. I said, that's absolutely crazy. There's no earthly reason why you need to be in the office. And they went through their particular medical condition. I said, well, what does the employer know about the process? I said, well, I don't think they know a thing. So we gave them, basically, here's the information, spoon feed it.
Yeah.
This is a request. This is what you should be doing. This is whatever. And he gave him all these, websites and stuff because the person was a researcher, made life easy. And well, it was granted. On the flip side, I had a company come to me, this is pre-pandemic. We hired this new person. That's the key fact here. And on day 2, they want this particular accommodation, and go through the details. Why'd they tell us to me on the interview? I said, well, I didn't tell them the interview because this is, whatever. Well, what are we supposed to do? I said, well, you have the resume. How many years were they working beforehand? Like 10, 15 years, whatever it was. What'd they do with the previous job? What sort of accommodations did they have there? This didn't, come into existence between the last position and you. What went on there? Gee, I don't know. I said, why don't you have a conversation with them about this? And don't you know, what my client thought was going to be this ridiculously expensive, how can I get myself to the situation, was a $15 fix.
Yes.
So
Yes.
the employee can bring to make life easy for the, quite frankly, employer who has no idea what he or she is, or they or it are doing, the better the people are going to be.
So thank you for saying that. I have to share something that I've been working on that I am hoping will be a conduit to sharing this information. I've created something called a work style profile, hashtag for work that fits. And it's a questionnaire that is designed for the individual to be able to self-reflect and articulate what are the conditions that invite their best work. And it deals with everything from chronicity to communication style preference. There is a page, a learning style preference, leadership, all kinds of things. And then there's a page which says nuance is necessary. And the way I'm building this is so that the individual can choose to share whatever they want out of this. But the idea is, how is this not part of an onboarding process? You've decided someone's got the skill, they've got the talent, you want them on their team. Let's have a conversation about what invites your best performance. And to use your words, Stuart, it's about conversation, but facilitating it so that the employer starts to broaden their thinking about what's relevant here and to make sure the individual knows what it is. So Raphael, you can put a link to the work style profile if you can in the chat, just for everyone who's attending. But
I wanted to jump in. Claire, do you mind if, just because on that point, I mean, that's phenomenal that you're doing that and kind of facilitating and a candidate's ability to really think through what brings out their best work. I mean, recruitment and hiring done right, those should be some of the foundational questions that you're asking, right? Because it's not a unilateral exercise. And so even when we hire at our firm, and I have another business as well, a HR consulting firm, I mean, we always want to explore and really canvas what will mutually make this a good relationship. And that really is asking what brings out your best work. A lot of employers might be a little reticent to get too much in the weeds, because sometimes when you ask questions that could reveal limitations that are, intersect or can be tethered to a protected ground under our human rights legislation, they may feel that they could be exposed to the risk of, if somebody doesn't get the job, they could turn around and say, well, I didn't get the job because I revealed this. So there is a bit of a line there that would make a number of employers a little bit concerned about that. But just because I can't help myself to circle back to some of what my colleagues mentioned, Madelena raised about how, some mom and pop shops, for example, may be a little less sophisticated with respect to understanding.
Great word.
Sorry?
I said great word. That's what I was trying to say.
Yeah. but maybe a little less sophisticated with respect to understanding their obligation to accommodate. And our legislation unhelpfully, but I think intentionally, doesn't define what undue hardship is, because
that was my question.
Yeah, it doesn't. And I think it would be great to know, but the reality is accommodation should be undertaken on a case by case basis. And I think part of the reason why we don't have a definition for undue hardship is because there can't be this blanket application of, okay, yeah, we're at undue hardship. You really have to go through the procedural accommodation exercise, really exploring what could work, what could be feasible. So, to Stuart's point, though, a lot of organizations and employers, they don't avail themselves of what they need, which is sometimes if you're dealing with, let's say, a complex mental health accommodation, you may need to source expertise to help you to determine what is possible or what is needed, because you may not be equipped internally to make the type of assessments or even to know what questions you should be asking to determine how you can accommodate. Because ultimately, for a mom and pop shop, getting to undue hardship may be a shorter track because there may be less options than a 5,000 per employee company, right? But one thing that always is going to be the kind of foundational assessment is undue hardship. Madelena raised right on point. It is a very high threshold, and essentially, if you're going to, for example, cite that it's too costly, what you're going to be asked to do is to pony up the financial information, because you have to show that the accommodation is going to, let's say, for example, what the employee determines as suitable, what may be possible, that essentially would render the business not viable as a going concern. So it's a very, very high threshold in our context. So
you also have to explore other financial options such as grants and so on, that may be available to you. Like if the business would have to be able to demonstrate. There is a sort of loose definition within the, I'm sure you're referring to that, Ontario Human Rights Tribunal's sort of guidelines, that speaks to sort of what it is that is required of the employer in order to establish undue hardship. And it's funny that you mentioned the mom and pop shop and the business going under. I always use the example when I'm speaking to people and employers. If your employee suddenly needs a wheelchair ramp, for example, a mom and pop shop that makes $20,000 in profit a year, and that ramp is going to cost $10,000 a year, that could potentially reach some level of that threshold, but Amazon is not going to be able to, for instance. Not trying to call them out or anything like that, but just, a big company, Amazon, whatever it is, that has 5,000 employees, is unlikely to be able to demonstrate that financial cost, that $10,000, has really any kind of impact on their operations. Whereas the mom and pop restaurant, very likely that $10,000 is, paying for their ability to live if their profits are in kind of a range.
I'm understanding this point of undue hardship for the employer. What's really interesting to me is to start to understand how we quantify undue hardship for individuals. Coming back to the 125 kilometer commute should be fine for you. It's a much higher level, probably tied to ethics and understanding human health.
The employee doesn't have a duty to accommodate up to the point of undue hardship, though. Only the employer does.
This is my point. It's actually undue hardship versus undue hardship is what we have. The undue hardship of an employee versus the undue hardship of an employer. But the undue hardship for an employee, I'm thinking there's not much of a measure for this articulated or understood. It's not even written in.
Well, that's just because it's not an obligation. Like the duty to accommodate includes the duty to accommodate up to the point of undue hardship. The accommodation is provided by the employer, not by the employee, in the legal sense. So
and just kind of stepping back from the strict legal, I think the undue hardship is what is embedded in the accommodation request itself. What you're saying is, I'm unable to perform work as it's required, and I need an accommodation based on. So I think that's where it's actually woven in from the employee perspective.
Exactly. It's just different language. I think it's right. There's an undue hardship on the individual, and they're saying, whoa, I need some help because this is too much for me in some context. And I think that extends now to the commute and versus the employer. And it could be, there's potentially physical infrastructure that might need to be changed. But often what we're talking about in terms of accommodations now is flexibility of time and location, which is now what I interpret it to be for leaders is putting this belief that collaboration is better in the office and putting some of these things aside. I think there's a greater cognitive load on the leader who is not used to managing a dispersed workforce. And some of the control and need for control and convenience and want to press rewind is coming from a resistance for that extra complication, potential lack of skill. And I'm wondering where undue hardship would be for an employer under that. I don't think it probably exists in terms of leader. No, you're going to have to figure it out. There's no cognizance in our society right now for the level of cognitive load that we're dealing with in different fronts. And I think it's just an assumption that no, you'll figure it out.
I will say though, in terms of junior, for example, junior lawyers, I go into the office a couple days a week. At my previous firm, I wasn't going into the office at all. And I think that, when I first started there though, I was in, and I do think that there is a loss in terms of sort of like mentorship and comfort in like popping by someone's office to ask a quick question. It feels much more invasive as a young lawyer or a young employee generally to seek that guidance. If you're picking up the phone, it feels like such an interruption. And I do think there is some value in respect to there being an in-person presence. I'm not saying that it has to be for every single employee, and if your accommodation is, you know, actually necessary and required and supported and so on, you don't have to be the one who's providing that sort of insight or support for sort of people coming up in whatever your field is. But I do think that one thing that we did like sort of lose a bit, and I'm not a big advocate for office culture or anything. It's more so that I think that, I mean, I think office culture is important, but I'm not like advocating for like it being cool to be in the office and go for lunches. I think that like just the accessibility of people who have sort of the who've been through it already, and you can just pop in and be like, hey, do you have 1 second? I think
you know
it
what?
is important for
I hear your
cleaners.
point. I hear your point. I want to pick up on the fact that you said just pop in for office lunches. I mean, actually, part of the reason that culture works is because social connection is bedded in. My work in Tokyo, I wanted to go in because we went for lunch every day. That
Right. I just meant,
so,
yeah.
yeah.
I just meant like, I'm
What's
not
really
necessarily saying everyone has to be there
yeah.
to go to office
No,
lunches.
But
It's more
what
for
you're raising,
like,
there's a lot in what you're saying, but what also in what you're saying is what is also prevalent in a lot of leaders is false consensus effect and status quo and believing that what works for them ought to work for everyone else. When I was in my personal situation, I followed up with 2 levels up long afterwards, probably about 3 years ago. What was the reasoning behind the insistence that full office attendance was required? And I was given the word mentorship. And I can tell you that in my tenure there, I never once heard the word mentorship. So, you know what, if some of these things are important, then organizations need to be finding ways to build that in structurally, foundationally, relationally. It can't be this fallback. You'll like a podcast that's going to come out shortly with Chris Dyer, who wrote Remote Work, and I think it's The Power of Culture. I've got his books around here somewhere. I had the interview with him last week. Gone fully remote. We're looking at Glassdoor just giving up their offices in Chicago and San Francisco, Atlassian, GitHub, all companies who are embracing learning to work differently and build culture differently. So I think there is a lot of reticence, and I think it's old school thinking that clings very much to this was easier. One CEO I spoke to last year. Oh, I love it when I can just go outside my office and have that 2-minute conversation with someone. At the cost of a 3-hour commute for that person every day, you got your 2 minutes, maybe once that year. So is that reasonable? Is it reasonable? I think there are conditions where it works. And I think that figuring that out is part of what
I
I'm
just want to
about.
clarify. I said it doesn't have to be every single employee who is available for these opportunities or this sort of presence.
You're
And for
right.
instance, I'm home not every single day. I work from home 2 days a week. I'm home right now.
Yeah.
But
I'm
there's no
Madelena,
mandate.
is that there's often an argument, and I wonder how much it translates into decisions in the courts from leaders. The CEO that I spoke to said, oh, every time you say something, Claire, I recoil. And then I think about it, what you say makes sense. And what I wonder is if there isn't somewhat of a, well, my experience was this, therefore,
Oh, the rite of passage thing is real. Yes.
Yeah. Can I jump in for just one quick second?
Yes, please.
Just with something. And Stuart, I'm mindful we haven't given you a chance to jump in a sec, but I want to double back to one of the first comments that I made around having a solid why. And I'll tell you, I've dealt with a lot of employers. I'm dealing with a lot of employers right now that are struggling to get their working arrangements right. And I remember back very early on in kind of mid-pandemic, there's a large company, and they decided, we were having a conversation, and they said, we're going to require people to come, our employees to come in 1 day a month. And I said, that makes to me no sense. And we're also in an era right now where employees are tire kicking, they are pressure testing and challenging leadership decisions, right? Because, you know, a lot of things aren't well thought out. And lo and behold, after, you know, they did it for a while, and then they said, well, you know what, the 1 day a month isn't working. And now we require like 3 days a week. And they, like, employees just showed up with, like, you know, pitchforks and torches, right? Hell no, we're not doing this. It doesn't make any sense. And it didn't make any sense. So just going back to, you have to have a solid why. In some organizations, in some environments, you know, getting together, working proximate is something that maybe the employees want. In my workplace, you know, people agreed. We did it very collaboratively, had our whys, but said, okay, what would you like? 2 days a week is where we landed, right? And
Well,
so,
you're talking
and
about,
that,
yeah.
go ahead. And that, so in some environments, because they found they collaborate better for reasons that Madelena mentioned, they can pop in and get guidance, and you know, we can, you know, still have that ethos as a team.
Yeah.
And there are some employers and some organizations that have had a lot of attrition where, you know, they're onboarding people remotely, don't have that onboarding down pat, and people are working with people that they've never met before. So it's very complex, and it's not one size fits all.
Agree. So,
right?
you know, I mentioned the work style profile. That little piece of self-inquiry and a decision to share that with the team is part of what I call a total teamwork program, which is encouraging leaders and their teams to come together, to have conversation, to see each other with compassion, and then get creative and co-create the way they work together in a design day. So everything you're saying is, yeah, it totally resonates. I think what I've heard today is that we're afraid of the conversations sometimes because we think it's going to be too complex, too difficult. We won't be heard. We don't understand. So I'm hoping that in this hour, which could have easily gone on and on because it's a really rich discussion, I think what I'm inviting people to do is have the conversations, do your homework and have the conversations, because you might find that way to compromise through compassion for each other with that shared objective of we want to get things done. I think I have like 1 minute or 2 minutes left, and Monica from Ireland has put some comments and questions in the chat. And there's one particular here in terms of caregiving. How is that being viewed by the courts? As you talked about family status, but what if you've got a partner who's
Marital status would apply.
it would.
The family status would be you, as you looking up, you taking care of your parent, or you taking care of a child that you are responsible for. Marital status, things like common law or marriage, or, you know, ostensibly partnership, where it's like a long-term intensive partnership, you're taking on caregiving responsibilities, that would also apply. And there's also things like under the ESA, there's caregiving, family caregiving leaves that are protected, job protected leaves of absence if necessary. So it does still fall in that context. I think I replied to Monica privately, but
lovely. Yeah.
Yeah.
Well, thank you for that. Thank you. This has been a fascinating conversation. I'm hoping people leave optimistic. Any closing words that I know, Stuart, is there anything you want to say? Because I want to make sure that you get a chance to maybe leave a closing word here as well.
Sorry, Stuart, I think you might be muted.
I think he's okay. He's okay.
Oh, I couldn't. Sorry.
That's okay. So I come back to Laura's first point and my first point as well, which a lot of this is just a microcosm of the lack of communication and the lack of thought process that there is. I'll give you a success story. It's a work in progress, but I have a client, relatively sophisticated, large client. Some of the employees must be in the office. Others must work at home. Why? Some of the employees are salespeople. They need to do outside sales. They need to have face time, but that didn't justify it for everybody showing up. Now, the ones who don't have to be there, there's other issues that's still a work in progress. I don't know, they're really doing work and, you know, issues that everybody faces, but the company is very proactive of how they do it. They try a thing, they see how it works, they talk to people about it, they see what's going on, and it's a success story. It's a work in progress, but again, it works for their particular company in their particular industry. As I think was said by a couple, Clary said, I think Laura said as well, there's no one size fits all here as well. And as long as
Collaboration.
yeah,
Very important.
Besides the mom and pop and Amazon, but as long as leaders are willing to embrace the issue, to look into the issue, and remember one other thing that's out there. There's study after study. People leave employment not because their job was miserable, not because the company is miserable, their supervisor. The number one reason why people leave, it's they couldn't get along with the supervisor. So if the supervisor wants to make life easy, wants a good team, these are the types of issues the person's going to have to think about and figure out the best way to address. May not be that person addressing them, but they're going to have to deal with these issues some way, somehow.
Yeah. This has been riveting. I'm sorry we've gone 3 minutes over. I heartily apologize to you for that. Thank you so much, Laura Williams, for your contribution from here in Toronto, as well, Madelena Viksne also from Toronto, and Stuart Silverman joining us from Boca Raton, Florida. It has been a very delightful hour full of learning from me and hopefully optimism and insight spread to all who are listening. Thank you so much.
Thank you, Claire.
Thanks, Claire.